Our last remedy is the so-called offer to make amends. This can act as a form of alternative dispute resolution rather than technically just as a remedy at the end of a court case. What is an offer to make amends? Have a look at Part 3 of the Defamation Act and work through the different sections that I'm going to show you. Basically, an offer to make amends can be initiated by the publisher of a defamatory matter or by the aggrieved person. A publisher can make an offer under Section 13, that is, they can start the process. And it can be in relation to a matter in question generally or limited to particular defamatory imputations. And if there are two or more people who publish the matter, an offer to make amends could be done by one of them or the group of them, or any combination of the number of people who were the publishers. In addition, an aggrieved person can actually ask for an offer to make amends under Section 14. They can do this by giving the publisher a concerns notice stating that they were concerned over the publication of the defamatory matter. It must be in writing. It must inform the publisher of the defamatory imputations from the alleged publication. And within 28 days after that, the publisher may make an offer to amend. They can also choose not to do so, but this can be an early and easier option for an aggrieved person to seek a remedy without going to court. So what's in the offer to make amends? The publisher makes this offer to make amends and they must do so in writing. It must be able to be readily identified as an offer to make amends. So it could be a letter, could be in other formats, but it's got to be in writing and it's got to be easily identified as an offer to make amends. This would usually be done if you work in a law firm that works with defamation. Have a look in by having a look in their precedent bank. Excuse me. They will have offers to make amends. Otherwise, a letter with a heading offer to make amends or similar wording would be another way that you could do this. If the offer is limited to particular imputations, that has to be stated in the offer, because remember, this option of an offer to make amends can be for the matter as a whole or for particular imputations only. It must include an offer to publish a correction. An offer to make amends doesn't work unless and isn't an official offer to make amends unless it has that offer to publish a correction. These items where I put must, I'll note for the students who are new to statutory interpretation that this comes from the wording of the sections. The sections say you must do these things. When it says must, that means it's mandatory. If you're going to make an offer to make amends, it absolutely has to have this must list in it. Another thing that they must put in is if the matter has been given to someone else, the offer to make amends must include an offer to take all reasonable steps to tell that person that the matter is defamatory. And there must be an offer to pay the expenses of the aggrieved person, that is the potential plaintiff. And that can be their expenses before this offer, as well as in considering the offer and after the offer. There are also some things that the plaintiff might choose to, the defendant might choose to do, the publisher. This is maybe, maybe not, because the wording of the section says may. May means it is possible but not mandatory. They may include offers to redress harm. They may offer to publish an apology. Note here, they must offer to publish a correction, but they can choose whether or not to offer to publish an apology. They can offer to pay compensation, but they don't have to. They must offer to pay the aggrieved person's costs, that is usually things like seeking legal advice, etc. But they can offer to pay additional compensation for lost income or for damage to reputation if they choose. But they must offer to pay the direct financial costs of the aggrieved person in relation to the defamation and the audit and the offer to make amends. They may also include details of any correction or apologies already made. So if a person has, without waiting for an offer to make amends, chosen to make a correction or chosen to publish an apology, they could include that in the text of their offer to make amends. So for example, if they do the offer to make amends as a letter, then they must have all these mandatory things in it. Then they may choose to include a copy of any corrections or apologies or any of the other may items. So what is the effect of an offer to make amends? If the offer is accepted by the aggrieved person, the potential plaintiff, they can no longer sue and there's no longer any cause of action. Whatever was offered has become their remedy. So that will include, of course, whatever correction they agree to have published, any offer to take reasonable steps to tell a person that the matter is defamatory, and any expenses that they have incurred in seeking the offer to make amends or as a result of the offer to make amends, as well as any of the discretionary items. However, the potential plaintiff or aggrieved person does not have to accept the offer. If they don't like what's in it and don't accept it, then the matter can go to court. However, they run a risk. If the court looks at that offer and deems that it was a reasonable offer, the publisher can then raise that rejected offer by way of a defence. So they can say, I made the offer to publish a correction. I made the offer to pay costs. I made the offer, for example, to pay that discretionary amount of damages, etc. And the court can then decide, well, you've tried to make it better, the plaintiff has refused, and that is a defence and you don't have to pay damages for defamation. However, it is very much going to depend on the individual circumstances and the terms of the offer about whether it's going to be deemed to be reasonable. Under Section 20, they also make it clear that any apology that is offered in the offer to make amends does not constitute an express or implied admission of fault or liability, and it can't be used to prove in court, for example, an argument, it can't be used to prove the defendant was at fault. So a plaintiff can't go to court and say, well, I have an offer to make amends. The defendant offered to apologise, therefore they must be guilty. You can't use it that way. It can't be used at all to determine fault or liability. The court still has to decide if the three elements of the defamation apply and then whether any of the defences apply. So that's an offer to make amends. It's a really useful tool, particularly if you're working regularly for defendants, because they may try to minimise their liability, avoid going to court, and actually resolve a problem well before it becomes very expensive and before trials are involved. So that's the offer to make amends.